in our discovery, disclosed that Deutschebank, the Deutschebank who we had named as a Washington Corporation Deutschebank in the complaint.
Different entity?
Different entity.
They do it all the time.
Yeah, and it's not a Washington Corporation.
Right.
The people that are pursuing, that allegedly should have pursued collection of the promissory note is not the named defendant in our complaint because it's not a Washington Corporation. That even if we disagreed about the escrow impound, that we had overpaid about $25,000, and so we were not in default. And they wouldn't listen to us. The servicer didn't have any authority to agree with that.
And who's the servicer, by the way?
Homex Servicing.
Okay, let's get that on the
record. Which is now Ocwen.
Oh, geez. Okay.
Yeah.
Well, in fact, the servicers, like we're arguing in your case, cannot. We've got a servicer who can't be a beneficiary. The two are diametrically opposed. They don't.
Yeah, but I bet when you really get into the entrails of this thing, you're going to find out that they are connected.
Oh no, they're totally connected. I represent homeowners in the war involving foreclosure in this country.
We're here at kingcast.net, Mortgage Movies. Who do I have before me?
My name is Julie Herbert.
And Ms. Herbert, Ms. Herbert, I take it we're all attorneys here, but you're an attorney with a difference because you're actually in foreclosure. Or are you?
It's not exactly correct. In 2003, May 2003, my partner and I, and he's a lawyer, we refinanced our home, and we took out a $325,000 mortgage on our home, and we made, between 2003 and 2004, we made all of our payments. They were $2246.88, and it was a short-term note, and we wanted to pay off our home quickly.
Yes.
It had far more equity than $325,000. It's
yes.
on the water. It was valued well over $1 million at the time.
Yes.
So in January, February, March 2004, we made 3 balloon payments of $10,000 each to pay down our mortgage.
Yes.
And in November 2004, sometime before November 2004, 18 months after the loan started, the bank that we borrowed the money from went bankrupt or out of business or closed, and Deutschebank bought the note. I'm not sure when that happened, but when Deutschebank bought the note, the servicer changed, and so we started receiving notices that our payment was increased from $2246 to $2700 and $2900, based on the fact that the new servicer assessed an escrow impound for taxes and insurance.
Yes, they get you through the escrow. If they can't get you that first through the payment, they get you through the escrow, right?
Yeah.
Anyway, so go ahead.
So we're lawyers, so we knew that they were incorrect because we'd opted out of the escrow and we were not in default.
Right.
So we also, but they disputed it, and we kept trying to get them to also, the new servicer wouldn't credit the 3 $10,000 payments to principal.
Okay.
So we were concerned, so they served us with a notice of default in January of 2005 for the November 2004 payment, and we argued with them that even if we disagreed about the escrow impound, that we had overpaid about $25,000, and so we were not in default. And they wouldn't listen to us. The servicer didn't have any authority to agree with that.
And who's the servicer, by the way?
Homex Servicing.
Okay, let's get that on the record.
Which is now Ocwen.
Oh, geez. Okay.
Yeah. So we, my partner was a pretty talented real estate lawyer, and he said, well, just sue them. So we sued them we filed a complaint to restrain the foreclosure in Island County Superior Court to prevent a notice of foreclosure, a faulty notice of foreclosure.
Because you knew it was coming. It was incipient. So he said,
right.
We're going to go ahead. We're going to nip this in the bud. And what was the result when you went to court on that?
So we didn't go to court. They appeared, an attorney from Seattle appeared on behalf of RTS, which was the trustee under the deed of trust. And we explained the situation to her over the phone and said, you know, we can show this accounting that shows we made these 3 $10,000 payments and they weren't credited towards principal, so the order of notice of default is faulty, so you can't foreclose. And she said, well, I need time. I represent RTS. I don't represent Homex Servicing. I need time to get the accounting from the servicer. And so we anticipated, we noted a hearing to restrain the foreclosure, and usually when you do that, whether you're a tenant or a homeowner, there's an order that's entered that requires you to make your payments, whether it's your rent payment or your home payment, into the registry of the court.
Correct.
So we did not note the hearing because she said she needed time to respond, and we just started voluntarily paying our mortgage of $2246.88 into the registry of the court.
Fair enough.
Well, 7 years went by, and they did nothing. And my partner passed away in 2012, and then within a month after he died, they filed a motion to, and during that period, of the 7-year period of time, he became more and more educated about foreclosure defense, and his primary practice was foreclosure defense with fraudulent foreclosures. And
Absolutely.
he worked with attorneys all over the country on that.
Yes.
And then when he passed away, they immediately filed a motion to dismiss the case, the trustee. And at the time, the law had changed so much, I thought I would maybe go into mediation or modification. I agreed to the dismissal of the trustee under the deed of trust. And meanwhile, the Deutsche Bank, who had purchased the note, or allegedly purchased the note,
Right.
could not produce the note.
Of course.
And so they eventually, a year later, Deutsche Bank filed a motion to dismiss the case, and the court denied it because Deutsche Bank couldn't establish that they were a real party defendant. It's more complicated than that, because Deutsche Bank appeared through one attorney, but then in our discovery disclosed that Deutsche Bank, the Deutsche Bank who we had named as a Washington corporation, Deutsche Bank in the complaint,
Different entity.
different entity.
They do it all the time.
Yeah, and
I've
it's
seen
not
it
a Washington corporation.
Right.
The people that are pursuing, that allegedly should have pursued collection of the promissory note, is not the named defendant in our complaint, because it's not a Washington corporation. So the court found, and they admitted, that it wasn't the same legal entity. And meanwhile, between 2005 and 2008, we deposited about $100,000 into the registry of the court voluntarily.
Mm-hmm.
And so after 2008, we stopped depositing the funds monthly because they weren't accruing interest, and no one was claiming the funds. And so we started just depositing the funds in order to avoid dismissal of the lawsuit. All the while thinking that Deutsche Bank would eventually, that they would either accept the
tender of payments.
Yeah, they tender payments, or that they would, they would acknowledge the payments towards principal of $30,000,
Right.
or something. But the problem was that they would not negotiate with us, and we tried to negotiate with them. But part of the problem was that they reported it as a foreclosure on both of our credit reports back in 2004.